All right, it is Friday, August 15, 2025. Hard to believe summer is flying by so quick. And
Not
welcome
cool.
to Borderlines, a Canadian immigration law podcast. I'm Steve Murins,
I'm Deanna
Deanna
Loganatov.
Ganachov, right? Um, how's it going? Usually busy?
It's going, yeah. It's just like every time I think that we've become as like wild and crazy as immigration is going to get, like something wilder and crazier happens.
Yeah. I keep actually thinking about how we talked on a previous episode, how bizarre it is practicing when the government has gone from an ambitious immigration target to wanting to shrink Canada's population, yet the underlying laws haven't really changed. Some of the programs have changed, but at the actual decision-making level for like approving a work permit or an LMIA, there hasn't been a change, but it's noticeable that things are different, even though the law itself hasn't changed.
Yeah, the climate has definitely changed pretty dramatically, and it kind of makes you wonder about the rule of law in general when the
Mhm.
same piece of legislation, the same policy can mean entirely different things from one week to the next.
Yeah. The plan for today's episode, we're going to talk about a pretty big British Columbia Court of Appeal decision involving litigation that has been ongoing for some time, involving Mac's convenience store. And then we'll just take questions. The last time I said it would probably be a shorter episode than normal, and then we went the full hour. We'll see how it goes today. The Mac's convenience store case and the relevance to immigration, beyond it being a case involving an employer of foreign workers, those watching on YouTube can see Deanna's dog jumping on. All the more reason to subscribe to our YouTube channel. And
100%.
yeah, is that so? The case involves interesting intersection of employer compliance and immigration. We've talked about employer compliance before. We've talked about the intersection of employment law and immigration law before, and this case raises those issues. I have a pretty active practice in employer compliance, and one of the scenarios that frequently arises is where an employer is saying that it wasn't them, maybe, who misled a foreign worker, but a recruitment agency, a consultant, or a lawyer. That was involved, and this case directly addresses those issues.
Yeah. If I might just say too that because the stakes right now are so high for people that if something in an immigration strategy goes offline, people may lose forever opportunities to become permanent residents. For example, I was talking to somebody yesterday about they did a CELPIP test and their score was what it was. And then they asked for the score to be remarked. And in the meantime, there was an invitation that was run. Had the remark come down before this ITA came out, this
Mm,
invitation, they would have qualified. But after the remark came back, it boosted their score, but it was too late. And at that time, once the remark came down, the rules around points for skilled employment, for arranged employment, those had disappeared, and that variance in the score really might have foreclosed an opportunity, perhaps permanently. So I think that the idea of vicarious liability for other agencies, I think, is becoming more of a live issue just in
yeah,
general, because one mistake or just interpretation that's not right on, it can have massive stakes for people. And that might mean the difference between getting landed and being able to hit a target and not. So I think anyone in the service industry right now, particularly with the department talking about, amps against representatives, and, I think that there's a lot more representatives, and anybody involved in the immigration space has a lot more skin in the game.
yeah. And an underlying point that Deanna is making that those who aren't familiar with Canada's immigration system may not fully appreciate is that it's not the situation that if an application is refused, you can just reapply. A lot of these programs are lottery based, like the parent and grandparent program. Deanna was referring to express entry, where the government ranks people and the threshold for what ranking will qualify for an invitation to apply to immigrate fluctuates dramatically. And
Dramatically.
it can be the case where, you may miss the low draw and the points will shoot up and the points threshold may not go down to what occurred in the error.
Yeah, exactly. I mean, we've talked on previous shows about things like lawyer incompetence, all these things. Like I never felt before that we were running such a precarious kind of a practice where one tiny omission error could have such dire consequences for people. But that's really the environment that we're in right now.
Yeah, we've done one episode on incompetence of counsel. I think we're probably going to wind up doing a follow-up because there do seem to be a lot more decisions that are being issued involving this.
Yeah.
So going to Max, Max is a convenience store, probably across Canada, I think, but at least in Western Canada. And so this case involves a class action proceeding of migrant workers who sought to come to Canada under the Temporary Foreign Worker Program. I feel like the case has been going on for years. I know back when it first started, I knew some of the people involved. I think there seemed to have been a lot of lawyers, as there's multiple parties in this. But in any case, the foreign workers, they were from many countries. They were all living in Dubai. And there's a company called Overseas Immigration Services that charged these people $2,000 to attend a recruitment fair and a further $5,000 to $6,000 when they got their work permits. So Max, the convenience store, retained Overseas Immigration Services. And there's a few other companies, but just for ease of saying this, I'm just going to say Overseas Immigration Services and not list all of the other consulting companies that may or may not be affiliated that were involved. But they retained Overseas. Max retains them to assist with filing positions at these convenience stores. And they would pay Overseas Consulting a $500 success fee for every cashier and $1,500 for every supervisor. The workers are alleging that Overseas charged them for jobs, which is not allowed. Some of the workers also say that when they arrived in Canada, the jobs did not exist or it was different from what was in their contracts. There's a lot of claims that are being involved. In this litigation, it seems like there's certain issues that they're addressing before it gets into the full meat of the actual litigation. And so there were 3 issues that are being predetermined. The first, and this was the issue that was most of interest to me and relevant to me, just because I've seen this question come up in my practice, was Overseas, was the recruitment consulting agency Max agent in the recruitment process such that Max would be vicariously liable for any breach that Overseas did? And second, which is a question that really could pertain to most foreign workers on closed work permits, did the people who arrive in Canada who discovered that they have no employment options or that the terms were different, did they have a duty to mitigate those losses? We're going to discuss the first 2. The third had to do with the calculate, like whether income that they earned would be subtracted from damages. And we're not going to really get into that discussion. So getting into the Court of Appeal decision, the agency one. So the court starts by noting that when people actually got into like the colloquial, because I think you probably hear this too as like a lawyer, people be like, you're my agent, you're acting as my agent. And this term kind of gets thrown around. And so the court noted that the term gets thrown around in the general sense or the colloquial sense, and that a lot of people will just say that anyone who's acting on someone else's behalf is their agent. They'll say, your employee is the agent of the employer, or you hired a contractor to do a job and they're now your agent. But the court found that the definition is actually more narrow, and that agency is essentially a relationship between 2 persons where there's the agent and the principal. And the agency relationship is established when the agent can affect the principal's legal position in respect of strangers to the relationship by entering into contracts, disposing of property, and basically binding when the third party can bind the principal. This can be done
Yeah.
through
And I
actual
think this
authority
is
or
all,
just like a contract. Yeah, go.
yeah. No, I'm just saying that this is all important because sometimes, like, for example, if there's an overseas, it just happens that the name of the company, but if there is an overseas agent who's acting, and the workers, let's say, are looking for a remedy, Canada's courts are not that like they don't have jurisdiction to compel a, a party that's outside of the country to do any particular thing. So that, I imagine, is why the litigants want to tie this liability to the employer directly. And so that's where this whole conversation around agency comes
Yeah,
up, because you want to actually draw the tie, the legal tie between the overseas actor and the domestic employer, and hold them responsible for the losses of the workers.
exactly.
Yeah.
And so the court here found, though, that overseas was not an agent, and that at no point did any, like, was there a finding that uh, overseas could bind Max contractually. Overseas was responsible for finding candidates, screening, setting up interviews, but that this did not make them an agent. It's interesting because the court got into the employer declaration form in the LMIA application, which is in the Schedule A. I'll just pull it up for those watching on YouTube. The actual LMIA declaration form, which says, and this is when you're appointing a representative, there's this line that says that I am compliant with and agree to continue to abide by provincial territorial legislation relating to foreign workers recruitment. I declare that all recruitment done on or that will be done on my behalf by a third party was or will be done in compliance with federal, provincial, or territorial laws governing recruitment. I am aware that I will be held responsible for the actions of any person recruiting foreign workers on my behalf.
Hmm.
And so the litigants here argued that this established a agent-principal relationship, but the British Columbia court uh, disagreed and found that while there was some assumption of liability, at least as regards to Service Canada, that this did not create an employer or a principal agent relationship. It also found that there wasn't also an implied relationship of agency and principal. And so that was basically the ruling on issue one. The relevance for employers who are going through the employer compliant process is, again, like in my practice, I've seen scenarios where uh, third parties, consultants, typically, or ghost agents were charging, and it wasn't exactly clear what the relationship was. It was clear that these third parties had misled or breached foreign workers. And it wasn't clear at all if A, the employer knew about this, or B, certainly to what extent the employer was liable. So the scenario that would arise, for example, is if and actually this is the scenario that seems to arise, is let's say there's a consultant or a lawyer or anyone who goes to an employer and says, hey, I have candidates, and the employer hires them. To what extent is the employer responsible for any misactions that that third party had done? Here, again, there wouldn't be an employer-employee relationship necessarily. Employers should know, though, that in 2022, the law was amended such that all employers have a duty to, quote, ensure that any person who recruited the foreign national for the employer did not directly or indirectly charge or recover from the foreign national the employer compliance fee or any fees related to recruitment.
And so the issue is that this case predated that legislation, and so it wasn't governed by.
Yeah, this case predates that. There still would be the issue of who is, like, whether they owe the like employees here or whether they would just be fined by Service Canada, or
Right.
would they be required to repay maybe the recruitment fees. It's also that, there's a huge issue that I don't think is resolved of what does that mean to ensure that the employer did not collect fees? Like how can a company ensure that? Is it just that, is it strict liability? Like, did they take steps? What is it? Do they just have,
Due diligence.
attestations from the recruitment company? It's very difficult,
Yeah,
and
for
it's a
sure.
growing area.
Yeah. It is somewhat disappointing, though, that this attestation essentially meant nothing in the context of this particular case.
Um, well, it's still ongoing, so there could be other avenues that they try to pursue them on. It's just on the pure agent principal
Mm-hmm.
relationship. The workers aren't going to be able to establish that.
Right.
And that's going to maybe become a question of like how they collect in the end or things like that. The other issue that is more broad and actually like really could impact a lot of workers was this duty to mitigate. So we
Mm.
talked with Aaron Brandt in our employment law episode about like to what extent do employers have a duty to try to extend their employees' work permit? That is sort of a live issue. This one is to what extent, if a foreign worker is coming on a fixed term contract, which pretty much all LMIAs are or LMIA based work permits are because there's a duration in the job offer, to what extent, if that employment ends, is there a duty to mitigate?
Mm.
And I think, most employers, the advice is generally, well, you treat your Canadian you treat your foreign worker employees somewhat the same as your Canadian employees. But there is a little bit of a distinction here that the court gets into. The lower court here, the British Columbia Supreme Court, which for those who aren't in BC, the BC Supreme Court's actually like the lower court, then the BC Court of Appeal, and then it goes to the Canadian Supreme Court. The BC Supreme Court found that there was no duty on the foreign national to mitigate, which, if it had held, would raise this interesting conundrum of okay, so let's say you have an LMIA based work permit for someone that's valid for 2 years, and after 2 months, it's not working out, so you have to end the employment agreement. To what extent do you owe this person now the duration of the contract if it's not fulfilled? Or all sorts of issues that arise. However, the Court of Appeal noted that absent a term to the contrary, an employer under a fixed term contract or an employee under a fixed term contract does have a duty to mitigate their losses. And they got into this issue because the judge noted there's a huge imbalance of employer-employee here in the foreign worker context because the
Hmm.
employee can't just go and find another job,
Right.
right? They need an LMIA, they need a new work permit. What is the expectation on them here?
Mm.
But the BC Court of Appeal disagreed and noted and they referenced the contract that, well, maybe they don't reproduce the contract, but they reproduce in the decision the language of the contract that everyone who has done a work permit will be familiar with, where it's what they call low wage, the standard contract, which is that if the relationship terminates, then a new employer, should the employee get a new LMIA based work permit, that employer takes over the obligation, or the employer has to pay for the transportation cost for the person to go back to their home country. So,
Just to like spell out this duty to mitigate, it's kind of like if you have a 2-year contract and the and the employee is dismissed, can they just kind of kick around not doing anything, and will the employer be responsible for the damages that they have suffered for that entire period of time? This is just a
mhm,
concept that's around in all kind of actions for damages,
yeah. And I mean, it's
meaning
pretty like
like,
when I was
you
in
know,
law school, I had to like, I was what was I in? I guess I was like leasing a room or leasing an apartment with someone else. And
yeah.
I had to, like, I was just moving, so I had to vacate. And the person in the other room, it was a 2 bedroom, said, well, does this mean you have to pay the full duration of the lease? And it was, no, you have to try to rent it. And they were able to rent it really quick. In
Mm.
the employee context, that's like they have a duty. Typically, it would be to find another job.
Yeah.
Here again, that's difficult. And what the Court of Appeal basically said was, well, we accept that it will be difficult, but while there are barriers to capacity, there's still a duty that they try.
Try. Yeah.
What I think is interesting here, and what the court didn't really address, is if the employer says, okay, we're going to pay your airfare back, does that sort of end it if the employee says, no, I want to stay?
Hmm.
Because,
That's super interesting.
right, like if the employer is saying, I'll pay for your airplane to go back to wherever, then they'll be able to legally work in their country. Obviously, their dreams of, remaining in Canada are dashed under that scenario.
Hmm.
But for the purpose of determining this duty to mitigate, does that duty include going back? Court of Appeal didn't really say.
Hmm. I guess, I mean, this goes to the conversation we had quite some time ago with Owen Logan about how do you quantify damages, when you're saying, what is the damages for lost opportunity? And so I guess perhaps it would be that, like, if they do pay to send you back, then you'd be calculating the difference between what your salary would have been in Canada versus what it would have been were you back in the United Arab Emirates, and so the damages that you would be able to recover are the differences between the two. So I don't imagine, again, this would be a very interesting question for Owen, whether or not it would be a full answer, or if it's just a matter of then you would just quantify them differently.
Yeah. And I would imagine right now that this would be a very live area because there are so many people who are having trouble with their LMIAs. Obviously, we've seen the unemployment numbers, which keep going up, which means a lot of people are losing their jobs.
Mm-hmm.
Probably not in the context similar to this, where there's exploitation involved, although I'm sure in some cases there may have been.
Yeah.
But it's tricky.
Yeah. Yeah, it definitely is. Like, what's your overall impression of the idea that there's no way of tying the liability back to the employer? I know since you work in the employer compliance space, I mean that's a win for an employer client who's in the middle of an inspection. But overall, I'm interested in what your
Mm,
thoughts are there.
I would say, I mean, having done this for multiple employers, there do seem to be the two subsets of employers who maybe knew that there was a breach going on,
Mm.
probably profited or did profit from it, and then those who really didn't know what was going on with either the consultant, the agent, the lawyer who arranged for someone. And I don't think necessarily, I think if they truly did not know, I think it's reasonable to not impugn liability on
For
them just
sure.
because I don't see any fault. Where it comes to this issue of ensuring that the recruiter didn't charge fees, and in British Columbia, there's the add-on that it's illegal to use a recruiter who's not licensed. So this hasn't seemed to come up as much lately. Then that is more tricky, and I haven't actually seen a case. I haven't done a case yet where usually that is not the standalone issue.
Yeah.
Usually it's much more common in the employer compliance context that the employer that was not paying what they were supposed to.
Right. For sure.
Um, I have not actually seen an audit that is purely based on recruitment fees being charged where the employer where that was the only issue.
Yeah. But I think that there
But
is
there's
a.
usually issues both
Oh,
with employer and uh, the recruiter. Um, and then I would have to think, I would think if I was advising employers proactively, outside of contracts and the recruiter attesting that they didn't charge, it isn't clear to me, or having an attestation as well from the employee to make sure that the recruiter didn't charge. It really isn't. it isn't obvious what insuring would involve.
Yeah, I mean, to me, I think it's certainly a best practice for an employer to make sure that there is some attempt to like some exercise of due diligence that's required if you're outsourcing to a recruiter.
Yeah.
Just because it is against the law for the recruiter to be charging the worker, and because in the context of an LMIA application, they're attesting to the fact that the law was complied with. I'm a tiny bit disappointed that the court didn't give any kind of uptake to the fact that was a commitment, whether or not it creates an agency relationship, but that they didn't give any uptake to the fact that they had committed, that they had undertaken essentially, that they were attesting that was something that they had done, and absent any evidence that they had actually done any due diligence. I'm sort of disappointed that there was, because I mean, when you look from the worker's perspective, there is often no way of recovering those paid fees or of recovering any of the damages that are real and actual damages simply because that actor is overseas. And I think that employers need to be mindful of that.
Yeah, and I mean the facts of this case, like I think this was 2012 that all this started. Like in the decade since, like if you think back, 2012 was like the ALMO, it was before the
that's right.
2014 changes. I'm not sure if what the laws governing recruitment were back then, and if it is as tight as it is now. Like certainly this predates the obligation on employers to ensure that employees didn't pay. I mean, this would even predate all the discussion about whether employees could pay the LMIA fee directly.
Yeah, that's right. That's true.
But I think in here, it's
people should not be taking their best practices from this decision, for sure.
No, definitely. The situation has definitely changed, but it is a live issue of like, if you don't know what went down. And I have had actually a few consultations, like they have with people who were adamant that they did not know that a fee was paid. But again, there were also other issues that arose during audit that really became much more the focus.
Yeah, for sure. I mean, I think right now, I think we have become much more aware online to the fact that, exploitation is kind of par for the course. And we're seeing so much of that, particularly now, given the willingness of people to actually outlay cash in order to be able to secure employment. And there has been a major blurring of the line between what is the fee for recruitment and what is the fee for consulting. And that's something that I think I got a bit of a sneak peek into this because I spent so much time working in the caregiver field. And so we saw it, I think, sooner than most other areas of practice where there were these overseas agencies. I mean, the Philippines was quite notorious for having a huge number of overseas actors. We saw this a lot in India as well,
Yeah, I mean, they got rid of arranged employment because of concerns that people were paying for jobs, essentially. Like it's such a live issue. There's so many parties involved, and there is a lot of finger pointing between third-party representative, employer. And so, yeah, I mean, hopefully this case just, at least as far as employer-employee relationship, and also the advice that you would be giving employers regarding duty to mitigate is helpful.
And due diligence efforts in terms of like dealing with a third party in the recruitment process. I think all of that is very much a live issue, and practices need to keep evolving.
Yep. Let's shift to questions.
Sure.
We'll see how many we get. We have one live question so far. We can take questions on any topic to anyone who might want to ask on this Friday morning, at least in Vancouver. And question one is the question that is asked every week.
Every episode.
And fair enough. I know it must be frustrating.
Yeah.
I don't actually know if there is such a specific draw. Well, so the question from Gautam is, would you please predict the CEC trade? Thank. And I don't think there actually is something called CEC trade. I think there's the Canadian experience class, and then there's category draws. So,
Uh,
um,
so maybe that's exactly what it is for like a category specific draw that involves trades as opposed to the actual federal skilled trades class.
yeah, the federal skilled trades class is, for all intents and purposes, non-existent. As far as invitations to apply in the last week, I think since we last recorded, which would have been August 8th. So in August 7, there was a Canadian Experience class draw for 1,000 with the comprehensive ranking system of 534. And there was a Francophone draw with 2,500 people invited with a comprehensive ranking score required of 481. It was actually the first Francophone draw since March, which was why the points had gone up from 379 to 481. And
You don't have that
yeah.
on the stage, by the way, Steve. I'm
Oh, I
not
don't
sure.
have it on the. Oh, I can
Yeah,
post it
yeah,
onto.
yeah,
But I mean, those are basically the numbers. As far
yeah,
as
yeah.
CEC trade, there has not yet been a trades draw. People are obviously asking, and as I said last week, if the category exists, it would be very embarrassing to publish a chart which says 0 in the category that we said exists. So I think there will be a CEC trades draw at some point.
Or a
I just do
trades
not
draw. You're
know
talking about a
when
federal
it
skill
is.
trades draw.
No, not a federal skill trades, the category draw.
A category
Federal
draw.
skill trades class, I don't think there'll be any draw.
Okay.
I think that that classification of draw, I don't think they've done one since 2019. The
Right.
category, there will be one.
Right.
Going to a question from Instagram, which is Instagram. So it's non-accompanying family and express entry. I think we talked about this before it became a huge issue.
Oh.
And so the full question is, what do you think about non-accompanying spouses and express entry and later sponsoring them under the family class? And what I would say is, if you're going to do that, you need to be aware that right now the department is probably sending hundreds, if not thousands, of procedural fairness letters involving this. It is the flavor of the month or year, and that it remains to be seen how the courts will rule on this.
This will go before the courts, 100%.
Oh yeah, like I have a few, I'm sure multiple judicial reviews have been filed. There seems to be, from what I could say, is there seem to be three situations where it's occurring. The first is where the spouse is not in Canada. The second is where they are in Canada, but the person in the response to the procedural fairness letter is providing what I would call reasonable justification for why the person is not accompanying. That there's some reason why they may not actually want to immigrate or acquire permanent residence at this time. And then the third is people who are responding explicitly stating that they knew that they were misstating, but that they wanted the points. And from
I
what
don't
I
think
have
it's
seen,
misstating,
those,
Steve. I have a
oh, no, I'm
problem with
saying what
that.
I've
But
seen in people
anyways,
writing in response. These
yeah.
are the responses going in that people, like I've seen procedural fairness letter responses submitted that say, I knew I was lying.
Wow.
But they wanted the points. Those seem to be going the additional step of misrepresentation, at least from what I have seen. And we'll see. There are going to be a
Yeah.
lot of
There's going to be a lot of it. I
this
mean,
is
it's the
one of those
question to
things where
me.
let's say there's 1,000 procedural fairness letters going up or out. There's 1,000 procedural fairness letters responses coming in. All are slightly different, and we'll
Mhm.
see which ones lead to the decisions.
Yeah. I mean, to me, just the question of whether or not it is so. Some cases, as Steve said, are being dealt with as a misrepresentation. Some of them are being dealt with as a Section 41 or Section 16 noncompliance. or a Section 41 inadmissibility based on a Section 16 noncompliance. That's, I think, how they're framing them up
A
now.
question not being accurately answered.
Yeah, exactly. But to me, I really struggle with it because I don't believe it's inaccurate. I don't believe non-accompanying means that they must be accompanying for the purposes of permanent residency, even though they're here as a temporary resident. I think that there's a question to me about what the legitimate expectation is, and the fact that in the past, you could choose whether you wanted your spouse to come or you wanted your spouse not to come, and that was not considered a non-compliance or a misrepresentation. And so I don't believe that's what the program guides say. I don't believe that's what the law says. And so again, this will be litigated, and we'll see how the court comes down on it.
Yeah. What I will say to those who are in this situation is that if your spouse is non-accompanying, I would not advise replying that I knew it wasn't true and I'm doing this for points.
Agreed. Yeah. I just don't think that you cop to a lie when, in fact, I don't think that there's anything in the act and the regulations that says that this is contrary to the law. I think that the option is there. Do you want them to process concurrently, or do you want them to not process concurrently? And so, if you have actually indicated that they exist and that they are here in Canada, to me, there's no lie.
Mm-hmm. So, I mean, we'll see. We'll see which
Yeah.
cases make it. Hopefully, this doesn't become a situation of bad facts making bad law, where somebody
exactly.
explicitly stating that they lied becomes the case that serves as the precedent.
Exactly.
It remains to be seen. Like the ones that the judicial reviews that I have, when I looked at the responses to the procedural fairness letter, I thought that this was a reasonable justification, and we will see how the officer dealt with it.
Yeah,
The pace of the
exactly.
federal court right now is such that I haven't seen any of the internal reasons for why the decisions were made. Going to some other questions. I hope I pronounced this right. Swarnim says that IRCC has a backlog of 410,000 PR applications. Even if they don't have any draws for the next 2 years, wouldn't they still be able to meet their PR targets? Yes and no, because a lot of that backlog is in categories that have small quotas. So I don't think that IRCC would say reduce the number of Canadian experience class people who become PR because the startup visa class has a huge backlog. I don't see that happening.
And the other thing too is, like, the refusal rates have never been higher. And so, some categories I read that, the HNC class, it's about a 45% refusal rate right now. We don't know how many of the applications in the backlog are in that category. Even with parents and grandparents, I mean, we've talked about the very high refusal rate just on things like, did your resume absolutely 100% reflect the response to your Schedule A form? If not, that's leading to refusal. So again, we're dealing with very meticulous screening, and I think that 410 in the box does not mean 410 approvals.
Yep. Swarnham says I pronounced his name correct, so that's good. I'll take my wins where I get them.
Yeah.
And we have another question, Gautam again, kind of related actually, which is whether we will see 4,000 ITAs for the category trades draw. And on this now, I'm going to have to load up the screen share for those watching, and we will just describe it for those who aren't, which is, here are the draws to date. So what do we have? We had 4,000 healthcare. All the other categories seem to be getting 500 other for healthcare, so 4,500 probably is a better way for me to have sorted and tracked this. Francophone obviously is in the over 10,000, and education was only 1,000.
Yeah.
So will trades get 4,000?
I put my money on 2 or 3 at tops.
Yeah, I have no idea.
Just a wild guess.
Yeah, I mean, in theory, Mark Carney is saying, he's tweeting all the time that Canada needs to build. They rushed through Bill C5, which gave the government the ability to fast track and ram through projects in the national interest. It was a bit interesting to watch because, like, similar in British Columbia, where the government passed a similar law, it was we need to go, go, go and build these projects. And they passed laws that seemed to upset especially First Nations who felt that their rights were being trampled on.
Mm.
And then when it actually came to, okay, we have the law, as far as I know, there haven't actually been any projects announced. So at some point, though, if they do actually start building, they will need a lot of tradespeople. And so maybe there will be a big skilled trades draw. I think that is it for questions. We had I think the big two actually, which are always arising, which is the size of the Canadian experience class, what's going on with points, and then the flavor of the month. That I think will just, I shudder to think how many applications are
Yeah, me
currently
too.
getting procedural fairness letters about this right now. Because I've
And
been
you haven't seen anything in the ATIP scene that explains why all of a sudden this turned into the flavor of the month, have you, Steve?
No, it'll take, it's so recent that
Yeah.
the ATIPs that do come out won't explain it yet. I do have, and I think people are digging, like, there's no question that starting in 2024, Immigration, Refugees, and Citizenship Canada's IMREP email started to tell people that this needs, that, what did they, how is it worded? That honesty is paramount and it could be considered misrep. And again, that's in response to questions that are stating, if I declare my client as non-accompanying, even though they're here for the sole reason of getting points,
Right.
is that allowed? And IRCC in that case is saying no. The question of another, so the question then becomes, what were they saying before that? And we'll see it. I've
Well, there
seen
have
one which
been,
suggests that they said, well, you just got to make
yeah,
sure that they're examined.
yeah.
But I haven't seen any. I'm sure people have ATIP'd. I know I've ATIP'd to try to figure out what was being said before, because I have used in judicial review, immigration representative, that inbox to build up like that. This is what was being represented. But
I
it's
think that there have
waiting on
been
the
some
ATIP.
posts online about people producing IMREP's messages where it was more stated, like, can I choose non accompanying even though my spouse is in Canada? And the answer has been quite unequivocally, yes, you can, as long as they are examined and there's no misrepresentation. And so, so I think that they definitely go both ways. I think it's just a matter of trying to
Yeah,
reduce that evidence.
and I think like the ATIPs that you're like, I'd want to get, like, the images that have been posted are, I don't know how well they'd hold up in court
Yeah,
because
for
they're
sure.
snipped. And I'm just trying to get the full set, because I think it is a very, very live question.
Yeah,
And
for sure.
obviously there would be a huge issue if the immigration representative's inbox was for years telling people that they could do this and then it pivots.
Changed. Well, again, it goes back to the initial conversation we had at the start of the episode, is what does it mean for the rule of law if one interpretation has pivoted over time? Now what was considered kosher before is now considered to be not so. You know, is that a rule of law issue? Is that a breach of legitimate expectation and therefore a procedural fairness issue?
Exactly. Awesome.
Yeah.
All right.
Good
We
chatting.
are out. Take care.